And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media. Joining us in studio, Attorney General candidate, State Representative Jason Knight. Let's get going.
The following program is paid programming. The views expressed on the following program are those of its hosts and participants, and nowhere reflect those of the ownership, staff, or advertisers of WNRI.
We'd like to roll the tanks, cue the Air Force, roll the Army and the Navy, and give us a carry-in. I'm not. 1, 2, 3.
And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media, broadcasting live on Woonsocket's Town Hall, AM 1380, 99.9 FM, and of course streaming live at WNRI.com, Facebook.com/The Coalition Radio, on the mighty Twitter at Coalition_radio, and of course the mothership at CoalitionNews.com. Well, as we mentioned in the run-up to the show, Jason Knight joins us. I will argue that constitutionally, politically, morally, ethically, financially, that the most important race in your Rhode Island state election cycle this time around is not the governor's race. And as much as I admire on a personal level a number of the folks running for lieutenant governor, it is not the lieutenant governor's race. The treasurer, we don't have any money anyway, so that doesn't matter. And of course, the Secretary of State, as far as I'm concerned, should be put in place for life. He is the godlike Secretary of State and the best that we will ever have in our lifetime, so enjoy it while it lasts. Which brings us to the role of the Attorney General, the chief law enforcement of the state, as it's been described, and so much impact in every aspect of Rhode Island's life. And that's why we want to get as deep in the woods as possible in the daily conduct today of the Attorney General's office. There's so many directions we can go, and we're going to try and do them all. Jason Knight, first of all, thank you for making the schlep from the East Bay up to Woonsocket. We're grateful for it. I'm just going to make an observation that there hasn't been a large presence of Attorney General candidates up here in the northern part of the state, and I think that's to their own demise, because this is an independent part of the state. There's a lot going on. Last night we were at a city council meeting debating the future of the Open Doors homeless center here in Woonsocket, talking about statewide issues, why the state isn't doing more to support it, why other communities, all the sorts of quality of life issues that ultimately involve the law. So thank you for joining us today.
Well, it's my pleasure to be with you, and thank you for having me. Thank you for WRNI for having us on. And I couldn't agree with you. I mean, I think that agree with you more. I think that it's on the candidates to remember that when you're running for votes statewide, it's the whole state. It's everything from Woonsocket to Westerly to Little Compton, all the way up to, Pawtucket, Central Falls, and everything in between. So I'm really glad to be here and talk to you today.
And in full disclosure, you and I have a history.
A bit, yeah.
Mostly a good one. But we first met on the battlefield of electoral politics in the East Bay. A good friend of mine, actually really one of my best friends, Darrell Gould, ran against you the first two times. It was the conversations were florid. Is that a good word?
Yeah, I remember those races. I challenged a 20-year incumbent, a guy who'd been sitting in the General Assembly for 20 years, and he didn't have the politics that I like. So I ran, and Darrell ran at the same time with a different set of politics. And of course, the voters prevailed. They got who they wanted, and I'm privileged to have served District 67, Barrington and Warren, for the last 5 terms, almost 10 years.
Yeah, no, absolutely, and. if all you have to do, if you've ever been in politics in the East Bay, all you ever have to say is, yeah, dude, and you know exactly who we're talking about. By the way, my favorite part of his tenure, and we're not here to talk about him, but was after a year and a half long analysis of the tax system here in Rhode Island. This is a gentleman who currently owns a liquor store, decided that the only area that needed repair was border liquor stores. That's Rhode Island politics. That's what you replaced. So let's get right into it. We often do, and it may come across as formulaic, but there's a reason why we do this. I'm going to call this, let's just call it 101. Let's talk about your background, how you got into the law. Talk about just a little bit about your service in the Navy and how it impacted you.
Yeah, a little back and forth. Well, listen, I was born in Rhode Island. My dad was a sailor on a Navy destroyer during the Vietnam era, and my mom, who was from Warren, was going to Salve Regina at the time. And they met and they dated. They got married, and we actually lived in Barrington when I was a baby. But eventually my dad wanted to go home. He was from Idaho, so we moved when I was an infant, and I grew up in Idaho, cowboy hats and shotguns and not very many traffic lights.
Conservative politics.
Conservative politics, but it was different back then. When I was growing up, that state is as red as Rhode Island is blue. But when I was growing up, conservatism really was like, stay out of my wallet, stay out of my bedroom. Good fences make good neighbors, and we'll all be fine with each other. And it really has changed. When I graduated high school, I joined the Navy. Didn't have any money for college, so I joined the Navy. I was a nuclear power operator in the Navy nuclear power, system. And I ended up serving on submarines. I got stationed in Groton, where I met, ultimately I met my wife. And when I got out of the Navy after 8 years of active duty service, I went up to Boston, where I went to college and law school, worked for a few years, and then really after law school, we needed some elbow room. So we came back down to Rhode Island and settled in Barrington, and, really just like a mile and a half from the mothership, which was my grandparents' home in Warren. And worked at the AG's office from 2016 to 2010, and then I was, an older lawyer, so I was looking to, I opened my own shop and began a criminal defense practice in 2010, which I've done all the way up until this campaign. And, I haven't taken any cases, in the last year or so, just because running a statewide campaign is a full-time job. And then I got elected to serve Barrington Warren in 2016. I've served 5 terms as a state representative, and I'm really proud of my service. I've had some big wins. As you know, I sponsored and passed the assault weapons ban, which just became law this past year. I was part of the small group of Democrats who rebelled against Speaker Mattiello over the issue of reproductive rights, and we managed to get the ball rolling to get reproductive rights built into Rhode Island state law before the Dobbs decision came down, stripping them away from all the other, all the women in the country who didn't live in a protected state. And I'm really proud of those accomplishments. But I've also done a bunch around criminal justice reform, public safety improvement. For instance, I sponsored and passed the law that reformed our human trafficking law to make it work better with other states. And I've did some DUI reforms as well. We've been working a lot on crimes that use AI in a really pernicious way to go after people, particularly young women. So we've built some laws around that, and of course, been steadfast with criminal justice reform and gun safety. Now,
to me, a critical point is the actual practice of the law. And folks who are new around here and may not have become enmeshed in our air quotes criminal justice system may not be aware that in this case, the Attorney General serves very much the role of the district attorney in most jurisdictions. You've got, we're all used to law and order, the big noise, the big thump, and then you open up with the police engagement, and then you go into the district attorney's office. And I'm not an expert. I literally play one on the radio, but having watched as much Law and Order as I have, I consider myself quite the expert, as well as a graduate of the Facebook University School of Law. Until you made the decision to move, and by the way, that's a responsible thing to do. These criminal justice, these cases can last years, and so you couldn't in good faith start. But you very much practiced the law on a really mechanical basis as well as a theoretical basis. A number of your competitors, and we're not here to name names, but a number of your competitors did their time in the Attorney General's office and then moved into other areas. What impact has literally day by day working the system had on you as a candidate for the Attorney Generalship?
That is such a great question, because I think the Attorney General's number one job is public safety. You're absolutely right. There's no district attorneys here in Rhode Island. We're one of 3 states that do it this way. It's Delaware, Alaska, and Rhode Island have an Attorney General who is the top prosecutor and handles all the criminal law in the state. And, about half the lawyers in the office work strictly on criminal law. And I think it's, I've got into this because this is where the rubber meets the road. I mean, I really wanted, when I first went to law school, the idea was I kind of missed I missed feeling like I was responsible for something big the way I was in the Navy. I was a nuclear power operator in the Navy, and, that's a big job. There's a lot going on there, and really, really bad things happen if you mess it up. So I wanted to combine this interest of really having a job that I felt served the public with this itch that I had around the law. It's just that intellectual itch that I just couldn't scratch without going to law school. But when I got to law school, I said, what am I going to do with this? Mm-hmm. And none of my family had been, they barely got past college. Nobody had been to grad school before. I didn't have like a lawyer mentor or anything like that. So I really said to myself, well, I guess lawyers go to court, and that's what I'm going to do. And what I discovered was, the law touches every part of our lives, but the rubber really meets the road, where the wishes of the community, as expressed through the law, hit the individual in the criminal law space. And that is, that's kind of the meat and potatoes of the power of the law. It can strip away somebody's liberty. In certain states, it can strip away someone's life. And I wanted to be in part of that conversation. So I actually did a year as a defender in law school at the Dorchester District Court up in Massachusetts. And then, I got my job as a special assistant attorney general, and I prosecuted cases and had those conversations and really stood up for victims and put people in jail. But then going on the flip side and walking that path as a defense lawyer to stand up against the government when it acts unlawfully and unconstitutionally has been a real privilege. And when I'm bringing that to the AG's office as your next attorney general, you'll get somebody who has seen the full breadth and scope of the criminal justice system, who sees how it can help victims of violent crime, it can help redress those wrongs, but also understand in a deep way the back end, what incarceration looks like, what rehabilitation looks like, what we need to do to provide for stability in some offenders' lives so that they don't offend again. There's nobody in the criminal justice, I like to say there's nobody in the criminal justice system who sees every single aspect of it other than the defense lawyer. A defense lawyer is there from, the initial investigation through the grand jury in a felony case, through the issues of arrest and bail, all through pretrials, discovery, trial, and then appeal and jail and parole and probation and the whole thing. Defense lawyers are intimately involved with all of that. Judges only touch the piece that they touch. Prosecutors only really touch things on the front end. Police are only involved in the initial investigation. But the defense lawyer sees it all. And I'm bringing that perspective to the AG's office. And I think it can only help because this role that the AG has is the most important thing that it does here in the state of Rhode Island. Yeah, we're pushing back against the Trump policies and there's a bunch of civil stuff that the AG has to take care of, but this is the core job.
One of the most nuanced parts of the job, at least from the perspective of an outsider, is how you charge cases. And that's been a real question in the last handful of administrations. I'm not going to single out one attorney general, but overcharging, undercharging, that's where, in a real sense, the rubber meets the road, because that's going to set the tone for, in some cases, some might feel a political set of charges brought. In other cases, the use of the system, the use of bail, the use of negotiations in terms of how a young man from South Providence or a young man from Woonsocket is charged and ends up impacting the rest of their life. And then there's a whole nother conversation to be had, probably on another show, about expungement. What do you have after trying cases, particularly gun cases, for years? Do you have a theory, a principle on that?
Yeah, and it's pretty simple. A senior prosecutor said to me one time when I was pretty junior, he said, Jason, the system is not fair. I want you to know the system is not fair. We make it fair. Prosecutors doing their duty as they are constitutionally charged to do that duty in service of the public. And when you have that as your touchstone about how you're going to approach the business of prosecution, what charges to bring, what not charges to bring, it becomes pretty simple. You look at the facts, right? You do an investigation to determine what you think the facts are in a particular case. You look and see, is there evidence that where these facts can be proven in a court of law? If there's probable cause, you bring the charge, but you bring it with the idea of, like, you have to ask yourself, number one, are the facts that I'm alleging what I believe to be true, what I think actually happened in this particular case? And number two, can we say that we have a reasonable chance of proving this thing beyond a reasonable doubt in court? Once you answer those two questions, right, then the question of doing the paperwork and bringing the charges is it's secondary. It's the first two things. Are the facts that I'm alleging, do I truly believe that this is what happened? And do I reasonably think that I have the evidence to prove this stuff in court? That's what you need to ask yourself in each and every case. It doesn't matter if it's a shoplifting case from Woonsocket or if it's a public corruption case coming out of the State House, and everything in between, and up to the biggest stuff, right? The violent felonies out there. If you can answer those questions, then you should bring the charge in safety and protection of the public.
In terms of communicating the overall nature of an investigation, I'm going to bring up a very specific, very local example, and I'll spare you the normal song I play whenever her name is mentioned, Lisa Baldelli Hunt. I recently asked the current Attorney General what the status was on the use of a report generated by the City of Woonsocket City Council on alleged high-level corruption, and acknowledging that part of this is federal, but acknowledging high-level corruption in a number of real estate transactions that ultimately led to her political demise. But and it can be argued that the former mayor, her shenanigans have put this city of Woonsocket on a financial death spiral because of the millions of dollars that it ultimately cost the city. And I could go on and on. But the point being, when the Hilo case was discussed, the Attorney General came out and had a rather frank conversation with the public. And he talked about the fact that while and this is my reading, feel free to correct me, that some of the behavior could potentially rise to the level of criminality, but based on Rhode Island law, it didn't.
We're switching gears from the former mayor to the governor, right? You said the ILO investigation?
Yes, I'm using that as a sort of an example because in that case, the Attorney General's office was very forthright and about the entire surroundings. Now, in the case of Ms. Baldelli Hunt, 2 years into this, after this very damning report was printed, there's still no acknowledgement as to whether or not there was even an investigation. And there's real life ramifications because Ms. Baldelli Hunt is running for city council and may win, despite having what most people will acknowledge is a horrific record. And yes, it's up to the voters. I'm going to land the plane now. The question is, to what degree should an attorney general's office communicate to the public about the ongoing nature of some of these difficult investigations?
I think you hit the nail on the head, and we've seen it in Rhode Island with these past few investigations about where, how the AG should think about their role as being an attorney for the people. Because look at it. I mean, the first word in attorney general is attorney, which means you are a lawyer first. You got to be a politician, got to get elected, but you got to remember that you're a lawyer. All the ethical rules apply in terms of relationships to your clients. You have a duty of confidentiality. You have a duty of zealous advocacy. You have a duty to look out for the interests of your client. And now, from the Attorney General's point of view, there's a lot of discretion there from the AG about how to go about that job. So, without getting into the specific facts of any one investigation or not, correct. I think that I want to see an Attorney General, and when I'm elected, I'll be this kind of Attorney General who really, really thinks twice about what they say publicly and asks themselves, is what I'm about to say going to be helpful or hurtful to the overall public discourse and to the better functioning of Rhode Island society as a whole? So when it comes to criminal law, we have some relatively established rules that have come down over the centuries from our common law, the common law in England, where our law comes from. And when it comes to crimes, you conduct your investigation and we don't really talk about it unless there's an imminent public safety issue that we have to deal with. Like, there's a bad guy on the streets. Watch out, lock the doors, that kind of thing. But when it comes to charging, particularly in a felony case where you send it to grand juries are secret for a reason. And the idea is that we may conduct an investigation. We may turn over facts that maybe somebody doesn't want to come to light. And if there's no crime that's actually discovered by the grand jury, it would be unfair to lay bare someone's private life before the public just because the grand jury found that there was no crime. And so generally speaking, when we're doing this kind of charging work, you're not going to hear about the investigation of a grand jury at all unless there is a true bill that comes down, which is a document in which the crime is charged. Yep. So when you're doing these broad investigations that ultimately don't result in a criminal charge, if it's done, it can be done through the grand jury process. It could be done independently. If it's done independently, you really have to think to yourself, all right, if I'm going to talk about this, let's say there's no charges that are going to come out of it, like happened in the ILO investigation. If there's no charges that are going to come out of it and I talk about it, how am I benefiting the public? Am I talking just so I can get airtime for me as a politician? Or am I talking as a lawyer serving my client to try to inform people what happened in a particular case and why the decisions were made the way they were made? I think it's a real fine line. This should be approached really carefully because in the end, you are dealing with people's lives who are part of these investigations, and you don't want to treat them unfairly. And that's the deal of the AG's office. You want to be the hand of the law, right? But you got to make sure that the hand of the law treats everyone the same and it treats them fairly. And because you really can destroy someone's life pretty easily as the AG by being cavalier.
And this all comes down to the conduct of the office itself. And there's two issues that come to, again, my mind with regard to the Office of the Attorney General as it exists in the state of Rhode Island. The first is it's been widely reported that there is a great deal of turnover that's occurred in the recent past. And I would imagine, from what I've read, there's this great tradition, you go down to, was it Morgenthau in New York City, of bringing on recent law school graduates and young lawyers and bringing them up through the system, through the district attorney's office, whether it be federal or, in terms of, like, say, the Southern District of New York or say Rhode Island or a city like Hartford, say. And you bring them up and they live the law. It's kind of like going to med school.
Right.
You have that same kind of immersion process. But if you can't attract and maintain talent, that has great impact on, well, everything. It could be, our high level review of hospital and medical law in this state. It could be our criminal law. It could be white collar crime. Let's take it from a positive perspective. What steps would you take as Attorney General to recruit the finest talent and create an environment where they want to stay for a long, because that institutional memory is critical, isn't it?
Oh, absolutely. And a good AG's office and a good district attorney's office and a good public defender's office anywhere has a pipeline. You know, you go into the law school. Look, everybody who goes to law school, for the most part, wants to have a job when they get out. The law schools have, each and every law school has a career services office, and you should really have a strong relationship with those career services offices, particularly the regional ones that are around us, and provide those opportunities for internships and for people to come on in their summers to, learn the law. And, every summer, the AG, if you're in district court or you're in superior court, every summer, there's just this flood of interns that come into the criminal courtrooms, looking to learn, looking to be a part of this, because people go to law. There's a lot of folks who go to law school and say, this is what I want to do. And that's going back to that thing I was talking about before. This is where the rubber meets the road. This is where the power of the law impacts individual lives in a real and concrete fashion. There's plenty of people who want to be involved in that conversation. So it's having a strong pipeline of interns coming into the office. It's being really thoughtful about converting some of those internships into paid positions. And this is where Rhode Island falls down on the job a little bit, it's providing the incentives for someone to stay and really make a career out of service to the people of Rhode Island. You have to provide a real career path. You have to provide a real set of benefits, a reason why somebody would stay and want to do public service. It's not going to pay as much as private practice, but it should pay enough so that you can have a really decent career and raise a family here in Rhode Island. And that is somewhere where Rhode Island has been a little short-sighted, I think. So one of my goals in the office is to establish those career paths and make it an attractive place to come and stay and sit down and do work that you want to do for the rest of your career. Now, that's not going to be everyone. A lot of people, frankly, come for 3, 4, 5 years to get the trial experience, and then they want to go to the private world and work those cases and make more money, or work on something that doesn't involve the AG. Maybe they're super interested in, I don't know, there's 1,000 different ways to go. Maybe they're super interested in commercial litigation or mergers and acquisitions or the business side of things or transactional. The AG over here just doesn't do that. But you can gain a really firm footing in the law and serving clients and making decisions on behalf of your clients as a young prosecutor. And, but if you want to stay, if you want to continue to do the work of the people and protect the public, we should do everything we can to make that opportunity attractive.
And then, of course, there's the win-loss. And it's an incredibly nuanced conversation. It's complicated. Very often there are so many, I keep using the word nuance today. That's kind of the word of the day, I guess. But
the law is not easy, man.
No. But in looking and doing some research and from personal experience, the current Attorney General's office does not have a stunning track record in wins and losses. Now, again, it depends what ballpark you're playing in, who you're playing against, any given Sunday, blah, blah, blah. From a personal perspective, the Daniel Dolan case serves as an example. And I've got a list here of high profile cases. I want to say that there were something along the lines of 29 acquittals out of 80 cases tried in 2024, which I'm told by people who actually are legitimate experts that that's not good. That's not a good batting percentage. But the Dolan case was particularly stunning to me. And for the record, I attended every single public hearing from the day the Daniel Dolan was charged. And this is
you want to tell people what that was about?
Yeah, the Daniel Dolan case, an off-duty Pawtucket police officer intercepted a young man who was speeding at an excessively high speed, followed him off the highway. Now, this is the key part. He was off-duty. He used a service revolver to shoot the young man after the young man had pulled off the highway. He was driving with an open container in an unregistered vehicle. And by the way, when there's unregistered, like, I forgot to renew my registration. I couldn't afford to renew my registration. And then there's taking the plates off another vehicle and putting them on that vehicle. He shot the young man, barely avoided killing him. And I think
Thank God.
Yes. And full disclosure, I've gotten to know the family very well. And he engaged in knucklehead behavior. But the last time I checked, speeding was not a death penalty case. Despite all of that, and despite stipulating in open court, I went to every day of court. I went to every hearing that was public for 2+ years. Okay. Despite all of that, he was convicted on nothing, not even the open container, not even, all right, we're going to whack you $500 and a suspension for driving on an unregistered vehicle. Nothing. Jason Knight, we've known each other for a while now. I will take to my death the sounds of the screams of that mom when he was
acquitted.
Yeah. On everything. I don't know how that happened. And again, it's unfair because I'm not a lawyer. I don't have the professional qualifications, despite how I appear outwardly. But I'll confess, I don't know what I'm talking about with regard to this. But, I have a list here of all sorts of cases where there were high-level acquittals or reversals. And I get back to one simple fact. There's a lot of folks, and, I'm not a Republican. I supported someone else for president. But currently, the Office of the Attorney General in Rhode Island spends a lot of time prosecuting Trump. But I've got one of the worst mayors in American history feels empowered to run for office again because there's been no public appropriation over clearly some pretty terrible behavior. And I've got these cases. How do we do better?
Well, I think you ask a really good question. And it brings me back to this point I made on the campaign trail. When we're hiring someone to be the next attorney general, you're hiring a lawyer not to do lawyer's work. There's staff lawyers, there's career prosecutors, there's career civil litigators who are there to figure out what the pleadings should look like, what the best language to use is, when to file an objection, when to do all the nuts and bolts stuff of legal work in a courtroom. What you're hiring an AG to do is be a leader, right? To make the political decisions about how to spread the offices of the resources around to address the needs of the people of Rhode Island and to address the missions that have been assigned to the Attorney General by both the Constitution of Rhode Island, because it has its own constitution, and the General Assembly. In addition to the traditional roles of the AG's office. So coming in, you really have to think about the priorities through that lens. What is going to have the most public impact right now? What is of the most significance? Obviously, in the criminal law world, you want to be going after violent offenders super vigorously and in a timely fashion. And those cases are just more important than, a shoplifting from the convenience market down the street. You shouldn't ignore the shoplifting, but when you're trying to figure out your resources, obviously you're going to take your senior, most experienced prosecutors, you're going to put them on the big case. You're going to put your junior guys on the smaller case, and they're going to do a good job there and pursue that case, and they'll build up their experience. On the civil side, we are in a really weird time right now. We are in dangerous and perilous times with this Trump administration. It is, I can't think of another time in the modern era where the states have been at such odds with the federal government over such profound and significant questions of federalism and the power of the federal government over the states, how much power the president can collect unto himself and just bypass Congress. Those are really big and profound questions, and we haven't dealt with them in any serious way since the Civil War. So in addition to all the other stuff that the AG traditionally has to do, this Trump piece has been laid on top of it, and it's been a real challenge. And the current administration has done a good job of responding to that challenge, but I do think that the office is stretched thin. So the next AG certainly will be me if I'm elected. It really needs to take a look at those resources and rebalance in a way that I've described to make sure that we're addressing things that are Rhode Island specific and continuing to hold the line against this craziness coming from the Trump administration.
Folks, we're going to take a very, very quick commercial break right now. When we get back, we're going to do a little bit of a lightning round on some criminal justice issues. And yes, we are going to spend a couple of minutes talking about the Second Amendment. Folks, we'll be right back.
Ever wonder why there are so many pizza places to choose from? Well, it's because there are so many styles of pizza to enjoy. And one of Woonsocket's oldest pizza parlors, Ollie's Pizzeria, has perfected the pizza science behind them all. Their traditional pizza is a delicious place to start. With Ollie's signature sauce, it's a perfect balance on flavor and texture. Looking for something thicker? Ollie's Pizzeria has perfected the Chicago deep dish. Not only thick, the sauce cooked on top brings a whole new flavor profile to every bite. Ollie's Sicilian half sheet also provides a thicker but airier crust. And looking for a thin crust? Ollie's has that covered too, along with gluten-free crust and Ollie's new grilled pizza. With an extended menu of premium toppings, there is a pizza waiting for you right now. And may I recommend their meatball? Call 401-766-1157 or stop by 204 South Main Street, Woonsocket to order with Ollie's friendly and courteous staff.
Rhode Islanders need new representation. Believe it or not, there's not a conservative, there's not a common sense congressman in all of New England. The government overreach, the tyranny of inappropriate government, has to be challenged. I'm not going to be far right. I'm not going to be far left. I just want to be far normal. The current congressman has a lot of money, but I have you.
I am so glad you're running.
I'm running for Congress, but when I see this support, we are running for Congress, and I'm going to take that message all the way to Washington.
Paid for by friends of Stephen T. Scully.
A Rhode Island tradition. Yacht Club Soda has been in business since 1915, located at 2239 Mineral Spring Avenue, North Providence. The soda is made there and shipped out to local stores. But did you know that you can shop and pick out your favorite flavors? Yacht Club Soda has 34 soda flavors to choose from. They have sodas, seasonal sodas, special releases, seltzers, sparkling water, and tonic, made with the finest extracts. Visit Yacht Club Soda's factory store and choose your favorite sodas. Open Monday through Saturday from 9 to 5. Do you have any questions? Call us at 401-231-9290. And did you know that Yacht Club Soda is Rhode Island's official soda? I think I'll try one of their new releases, either Yacht Club Sour Grapes or Yacht Up. Such a hard decision. Maybe I'll pick up both.
Hey, folks, we're going to get right back. Jason Knight is in studio. Representative from the East Bay is now running to be Attorney General. I promised folks that I would take this conversation beyond the Second Amendment, and that's what we're doing. We're really doing an analysis and by note, an explanation of just how the AG's office would work on a day-to-day basis, grinding out the law, if you will. Let's get right back. And we are the coalition, loud and proud, outrage, porn-free, civilly disobedient media. Again, broadcasting live on Woonsocket's Town Hall, AM 1380, 99.9 FM, and of course, streaming live at WNRI.com. If you're just catching this now, or you're listening and your friends want to listen, this will be up on iTunes at some point later on today. Joining us again in studio is Representative Jason Knight. He's running to be Attorney General, your Attorney General. And to me, the office goes well beyond some of the top of the fold headline stories that we often read about. There's a lot going on in the world of criminal justice reform. And I will just say this. Rhode Island considers itself a very, very progressive state, very positive, very, very, very proper, when in fact, as someone who supports criminal justice reform, there's a lot of crap going on and there's a lot of garbage out there, and it can be changed. So I'm going to do a little bit of a lightning round on some key issues I think that were covered fairly well in the open doors debate, but not so much the rest of the state. Bail on 32. Thoughts?
Well, do people even know what bail on 32 is?
My audience does.
Your does.
My audience does. But yeah, feel free to dive in and explain. These are subjects I've had a lot of the folks who are reformers on this on the show.
Sure. So super quick, when you are on probation here in the state of Rhode Island, and you have done something that causes the probation authorities to think that you have violated the terms and conditions of your probation, they bring you and they present you in front of a judge and say, Judge, we think this guy's a probation violator, and you have a right to a hearing, and you have and to have the evidence against you presented to you, but it's not like a full criminal thing. You don't have all the rights that go along with the constitutional guilty, not guilty side of things, because you're already on probation. You've already been found guilty. The rule of criminal procedure where all this stuff is done is Rule 32 of the Superior Court Rules of Criminal Procedure. And there's a district court analog. And so on bail on 32, they're often asking about, like, when you make this first presentation, you're brought before the judge, should you have bail or should you just be held without bail on the allegation that you violated your probation? Traditionally, it's been kind of an instant hold without bail sort of deal. The theory being you're on probation. We've alleged that you violated your probation, so we're going to hold you without bail as a danger to the public. And the bail on 32 movement is trying to address that, to say, really, before you strip away someone's liberty, you should hold off on that until the issue of whether or not they actually are a probation violator has been settled, either by admitting to your wrongful conduct in court that, yes, Judge, I violated the terms and conditions of my probation, or being found a violator after a hearing in front of a judge. So this is a public safety question. And my position is that judges need the authority for the very, very rare case when someone comes along who is a real threat. But there should be, we should have a presumption that goes towards bail until, all the facts are figured out, to figure out if you're a probation violator. And this is not novel. This is how they do it over in Massachusetts. And there's a whole lot less people locked up on that initial presentation than there are in Rhode Island. And the court systems, I've been doing criminal justice as a prosecutor and defender for about 20 years, and I've seen an evolution in how the judges are handling this. They give bail on a 32F presentation far more often nowadays than they used to. I think they got the memo on this a long time ago. But I know that there's still an effort to codify the approach into state law. So that's the issue. Right.
And ultimately, folks who are subject to incarceration again, and the lag time that can occur between a hearing and a re-release can be weeks, sometimes longer. And that can result in loss of an apartment, loss of job. There's a real quality of life issue. Now, since we're on the subject of codification, Rhode Island, from my perspective, and I want to hear yours, has, before Wayne Salisbury, the former head of corrections, temporarily administratively fixed it, had one of the worst solitary confinement arrangements in the nation. In fact, there exists, under international, I won't call it law, but under the United Nations human rights folks, passed something called the Mandela Accords, which, based on the experience of Nelson Mandela in Robben Island in South Africa during his incarceration, inhumane. The amount of hours spent in jail, the conditions of jail, the conditions of food in jail, the access to everything under the prior head of corrections was just terrible. And their refusal to either allow, or the head of the Rhode Island Department of Health refusal to engage in a fundamental health care audit, something I've challenged every single one of our facilities here at the ACI, leads me to believe that it's terribler, if that's a word, than it actually leads to believe. Because, of course, when you operate behind closed doors like that, suspicions grow. Is it time to codify, understanding that there's litigation going on right now, but is it time to codify a much more humane form of solitary confinement in this state? Because it is solitary confinement. They've got all sorts of euphemisms, but right now, I believe it constitutes cruel and unusual punishment. Just the sheer amount of hours that you're locked away and the conditions that you're locked away in here in Rhode Island. Your thoughts?
Well, let me say up top, I think that solitary confinement, as it's used in Rhode Island, is the wrong way to go, and we should be working to get away from it. Now, in practice, there's a ton of tricky questions about how to do that, how to do it safely, to ensure that folks in the prison and both the correctional officers and the staff and the inmates who are in the prison are protected from people who simply cannot conduct themselves in a nonviolent fashion. There's a few out there, and that's the real problems. Like, what do you do with these folks? But my understanding is that it has been way overused over the years, and that's what the lawsuit is about. There was a study commission at the General Assembly that really brought up some very, very troubling details, and then the movement just sort of petered out a little bit. There's been various efforts while I've been up there to try to codify the situation with solitary confinement. The problem is we get to a committee hearing where we're trying to figure out exactly what the facts are on the ground, and you just get all these competing claims. You have the correctional officers through their union representatives come in and say that things are going one way. You'll have the correction officials who represent the administration come in and say, no, things are better than they used to be. And then you get all kinds of horror stories from the public who comes in, either people who have actually been in the prison or their families. And it's really hard to sort out what the reality is. Candidly, I'm not pleased with the transparency of the executive, both the McKee administration and the Raimondo administration, around this issue. And I think that that's why I think that going forward, we need to institute a couple of real reforms. I think we need an advisory committee who can have full visibility into the prison system that is not part of the Department of Corrections. I want to see the Attorney General, and I want to see a couple of groups from our communities out there who are affected by some of these decisions. I want to see some law enforcement agents, police departments, whatnot, and maybe a few others on this sort of advisory committee who can fully see deep into the prison system and understand what the facts are on the ground, but not be part of Department of Correction, not be answerable to whoever the governor is at the time, so we can really understand what's going on. And then I think we need to recognize that solitary confinement is really bad. We should really work towards getting rid of it. And we should really work towards getting rid of it. And if we have to have it, and that often comes down to an issue of staffing and the physical layout of the prison facilities, it should be used as infrequently as possible and only as a last resort. But I don't think we can figure out whether it's a statute issue or a policy issue until we get some real facts on the ground. And we need to just refresh and see where we are on this. And we have to do it in conjunction. I think we have to do it in conjunction with the court case as well. It's a tricky problem. It's a problem that everyone kind of wants to sweep under the rug because it brings up some really hard discussions about how we're going to treat or how we're going to deal with, our inmate population. It brings up some hard and fast financial questions. Let's face it, our maximum security facility is very, very old and needs to be replaced. Our high security facility needs to be replaced or reconfigured. So part of solving this problem is going to be a financial investment of rebuilding some of these prison facilities. That is a lot of money, and it's a huge headache because of the politics behind it. But we need to upgrade these prison facilities, because right now they're built for a day when solitary confinement was the norm. We need to build new prison facilities where solitary confinement is a thing of the past.
Thank you for that. I want to spend 2 minutes on this because I want to give you an opportunity to respond to one or two very basic questions on 2A. APRA reform. Mike, of course, I've got a quick story. I'm a talk show host. I recently, last year, submitted an APRA request to RIPTA. It was promptly returned and answered. I submitted a second one. I didn't hear from them. This was strange. RIPTA folks are very organized. So I finally reached out and said, what's going on? And because the second one was not sent to the official RIPTA APRA email.
Shame on you.
All right. Although I sent it to the same one that I did the first one.
You should have known better.
Which is the one that they actually gave me. And I am not aware of a general publication of, APRA. They ignored it and said my complaint was invalid.
I can't believe you didn't mind melt with Ripta about this.
Yeah. So in 1 minute or less, do you support current legislation? Does it go far enough? People getting my good friend Steve Alquist getting charged hundreds of thousands of dollars to do some photocopying. It's clearly become politicized. Your thoughts? Somewhere along the line, we landed where we are with public records in that it's this cat and mouse game with the public authorities and the public that public record, we have to just go through this process every time. We need to come back to a time when public records are just public records. There's no question that you get them because they're public records if you ask for them. Mm-hmm. And the APRA law that's in place now has far too many exceptions. It has far too many carve-outs. I sponsored this last legislative year in 2026. I sponsored the APRA reform that's on the table, supported by the ACLU and Common Cause. It has roughly 47 specific changes to the law around all kinds of things: emails, police reports, the privacy exception, and really, most importantly, the procedure about how you request, who you talk to, how those requests can be made, all designed to make it easier. And it also has a piece in there which is missing now of a vexatious request provision where you take someone who is clearly just a troublemaker and try to tie an agency up in knots by requesting all the paper in the world. And there's a procedure to deal with that as well. I think it's a really good reform. I don't know why we're beating around the bush. We should just pass it. The governor's people object to it all over the place, but this is where the General Assembly can put on its big boy pants and frankly step on some of these concerns, because we really need to have more sunlight and more transparency into how Rhode Island operates for the better and for the good of everyone. Yeah, the current administration is opaque. Let's just say that. They're all opaque. They've all gotten more opaque. It's been a real problem. You see it at the town level. You see it at the municipal level. You see it up through the agencies. Everyone wants to play this cover your behind game when it comes to public records. The clerks, I shouldn't say the clerks, but I see situations where people are really hesitant to get out a record because they might catch hell from up top, right? From the executive office. Mm-hmm. And that's not right. Our government should be open for everyone to see into where they can see into. There's some things that always have to be privileged. There's some things that have to be confidential. Criminal investigations is the number one standout. And there's a bunch of really thoughtful, solid exceptions in the current law that we would keep in the proposed law. But no one should be afraid of losing their job because they hand out a police report or a contract or something to, WPRI or WRNI or someone like you. Or WNRI. Okay. WNRI. Listen, we've got about 3 minutes and I have close friends who are going to kill me because I waited this long to ask this question. We could talk all day long. We could. In 2 or 3 minutes or less, tell me why you believe, despite the qualms of the 2A community, why you believe that the assault weapons ban will survive constitutional challenge, if it's possible. Well, that's a big question, more than 2-3 minutes, but let me try to give you the big picture. Mm-hmm. I think that we have an epidemic of gun violence here in America. Mm-hmm. We know that states that have strong gun safety laws in place have a lower per capita rate of gun violence. And I'm proud to have worked very hard to sponsor and support and author a lot of those bills that have passed over the last few years, including the assault weapons ban, to help make Rhode Island safer. When it comes to the constitutionality, the issue is, are we, the Second Amendment is black letter law. You can defend yourself and you can defend your property and your family with a firearm. And you'll get no qualms from me. It is what it is. It's in the Constitution. But the types of weapons that are available to be used is we've had a long history of being able to restrict those weapons. And I think we can make that argument up at the Supreme Court. And I know these cases are going to be resolved this year, one way or the other.
I think we can make the argument that we're entitled to control the types of weapons that are allowed in the hands of the populace so that people's Second Amendment rights can be upheld, but we're not handing, flamethrowers to people out on the street or, in the case of what we're talking about, assault weapons.
Fair enough. Got a minute left. What did we call it? Shameless self-promotion.
Well, I'm happy to thank you for having me on. I think that Rhode Island needs in this next election. You are absolutely right. The AG's election is super important, at least as important as the governor's race. What Rhode Island needs is a progressive champion with a deep well of experience in state government, both in the business of the AG's office and in the AG's office and in state government as well, with a track record of getting things done to push back against the terrible policies coming from the Trump administration. You can learn more about us at jasonKnightRI.com. We're on Instagram and Facebook and Twitter, now known as X. And thanks again for having me on. I appreciate it. Please vote on September 9th.
And you can start voting, I think, today. Jason Knight, your candidate for Attorney General. Folks, we will be
tomorrow.
Great conversation.
All right.
Really had a great time. Thank you so much.
Thanks, Pat. Appreciate it.